And it's quite a lengthy question, and I want to actually touch on the points that she's raised so we can assist her as comprehensively as possible. And Liesl says, we bought a property through Easy Sell for my mother in March 2021. We did not register the property, and she didn't do this because the seller renewed a lease agreement after the OTP was signed. And she said that the terms of the OTP were that they would have vacant occupation of the property before registration. Now, obviously, here we find out that a lease agreement was renewed. She says that the seller also did not disclose that there were tenants on the property, nor did the transferring attorneys make any efforts to rectify this. She says the lease agreement, purported lease agreement, expired at the end of October 2021 and was extended to December 2021. She says till date, no lease agreement could be produced, although she has requested it numerous times. She said recently she was allowed to actually go and inspect the property. And when she did so, she discovered that the property was in a terrible state, and that there were a whole host of issues. And she believes that it was deliberately damaged, and that they had stated that this damages could be in excess of 80,000 rand. She's also incurred a lot of expenses with regard to accommodation and so forth, because of the delays that have now occurred due to the renewal of this purported lease agreement. She states that, look, in terms of COC, in terms of certificates of compliance, these are all now invalid because of the fact that the property has been vandalized, and that there's a lot of damage to the property. What she wants to know is, she says, can we as buyers not agree to register the property until the above issues have been resolved? She also notes that we have bought the property cash and all transfer fees have been paid. She will appreciate our advice on this one.
Oh, this is a nice one. We're going to have to break him up now. Bruno, you must, can I start and then you pick up the pieces that I leave out?
Sounds good.
Okay, so the easy answer is, I think this is one of the questions where I think our viewer, we could have a very nice solution for this particular person. So the first starting point is, this is not one of those questions that I'm going to answer and end with saying, I'm so sorry, the law doesn't seem to favor you today. I think the law is going to favor you. Again, to Bruno's disclaimer, I'm saying all of this, not seeing the offer to purchase and not knowing the exact terms of the offer to purchase. But if the lease agreement was anyway extended only until December 2021, even the easy answer is, even if they then concluded a renewal after that, but after the signature of the offer to purchase, which guaranteed vacant occupation prior to registration, that lease agreement can be voided based on the Nemo plus Juris rule. If you already gave the right of occupation to one party, you can't also go and give it to another party. You can't give away more rights than what you possess. And once you gave away rights, you can't give the same thing away again to another person. And then the prior extempore rule applies, meaning if the OTP was signed prior to the renewal agreement, the OTP will take precedent to that, which is obviously not usually the case, based on the principle of huur gaat verkoop. But in this case, two things. The fact that they're not producing the lease agreement is beautiful because it means there's a verbal agreement. The last agreement we saw was the one that was extended until December 2021, meaning we're now running on a month-to-month basis. The purchaser, the seller, must now give those tenants a month's notice of cancellation of that verbal agreement. They must attend to giving you vacant occupation. What you can do, and I think the more practical answer here would be to place the seller on terms in terms of the offer to purchase. I believe that the seller is in breach by delaying the process to not give vacant occupation prior to registration. But now you're going to have to check the terms of that offer to purchase with a very, very fine eye. And I might actually suggest getting into contact with SSL or Bruno Simao attorneys let's just have a look for you to make sure we are actually doing the right thing, and let us then, one of us then rather do that letter of demand for you, placing the seller on terms, because this is one of those not DIY law things that I would suggest. If I understand the facts correctly, I think it would be easy enough to place the seller on terms, demand that he gives vacant occupation within the allowed time. Once there is vacant occupation, and he now gave new COCs and everything, because that COC by now probably expired, or at least an updated confirmation that the COC is in fact still valid, then we can proceed to transfer. But because he's on terms, if you then cancel, you're not going to lose any money. In fact, you're going to have a damages claim against the seller. Bruno, am I overly excited and eager about this answer?
No, you're absolutely, I think you're absolutely on point. It's just, it's always been such a difficult position or dichotomy when it comes to occupation being given, say, on date of registration. So if the property must be vacant before registration. So my reading of that is paraphrased, right? But the purchaser reads it in a certain way. But we know that most of these sale agreements say on the date of registration, you'll receive vacant occupation. So I've had this argument countless times where one person's view is, until that date, I can do with it as I please, right? I'm not referring now to the condition of the property. I'm referring to occupation of the property. I can do with it as I please. On that date, I will give you vacant occupation, no worries at all. And we had this very same case when my client was the seller. And my client started acting malafide because everyone knew that there was no way we were going to get these tenants out by that date. But he kept saying, well, you don't know that. So as far as we're concerned, go ahead with transfer. I'm not in breach until we know for certain I won't be able to get the tenants out. So we go with it and take transfer, and then on the day of registration, oh, well, yeah, guess what? I wasn't able to get the tenants out. But now the flip side of this, and I've heard the argument differently as well, and this is where it starts coming to like repudiation of agreements and that sort of thing. The reality is, if the situation exists where occupation is not possible by the date of registration, whenever that might be, if it's not possible, that's a completely different story. So hypothetically, if transfer is supposed to take place within a reasonable period of time, let's say the next 2 to 3 months, but there's a lease agreement that goes until the end of the year, there's no way that their property is going to be vacant by the time that registration takes place. So as Cilna mentioned, this is something that's not DIY, because we're going to need to sit down and look at the facts and ask, how long has the tenant been there for? This verbal agreement, is there a time frame, or is it a month-to-month verbal agreement? When is occupation actually due? Is there a real threat that occupation won't be given? How are we going to deal with this? Because the transferring attorneys tend to push back quite a lot when it comes to this reciprocal duty. Like, I don't have to stop transfer because of this. Because it's not material enough. Take transfer. This is an issue that can be dealt with through damages or whatever the case is. So we need to come up with a strategy to push back on that and avoid transfer from taking place based on that. And then obviously the question also starts touching on damage to the property. And that's probably actually one of the easier approaches if you want to get out of this deal, is to look at the damage to the property and say, well, now the item isn't in the same condition as it was when I had bought it. You're responsible for this. So I'm actually allowed, and that's material enough to say, well, the whole thing's broke. I'm demanding that everything get done now, because it wasn't a question of on transfer. The reality is it needs to get done before anyone even speaks of the word transfer. So you could go argue on the condition basis and first you'd need to force them to remedy this and actually fix it. But if they fail to do so, that could give you room to cancel and get out of this. So that's also an idea. So you have multiple angles to approach this with, but it's not DIY. There's a lot of pieces to this puzzle.